for Personnel Policies and Procedures, presented by Guillermo Bettis of Kern, Augustine, Conroy, and Shopman. Please be aware that there will be a question and answer portion today at the end of the webinar. To avoid frequent interruptions during the webinar, please type your questions in the question box located on the right of your screen. They will be answered in the order received during the question and answer portion. Additionally, an electronic version of this presentation will be emailed to all participants following completion of today's webinar. Again, NJMGMA would like to thank you for attending, and I will now turn things over to Guillermo.
Thank you, Dawn. My name is Guillermo Beavis. I'm an attorney at Kern, Augustine, Conroy, and Shopman. We're attorneys to health professionals, and I'm looking forward to speaking to you today about an issue that I'm sure is near and dear to all of your hearts. I'm going to preface this by saying that I'm well aware that people who rely on PowerPoint presentations rarely have any power, and seldom do they make a point. But I'm going to try to persevere, dispel that notion, and try to give you some really good advice that you can use going forward in your practice. As you all know, I don't need to tell you, I'm preaching to the choir. Running a medical practice and managing employees can be difficult. Not having the right support structure and tools can make this already difficult task nearly impossible. An employee handbook that keeps you compliant with employment laws can make your life much easier. Now, generally, the purpose of a well-crafted employee manual will help both employers and employees. Employers can manage their employees more efficiently, and employees know their rights, recourses, and what's expected of them. So, employee handbooks. The simple question is, do you have one? If you don't, you're running an incredible risk of lawsuits, and quite frankly, you're playing Russian roulette. If you do not have one, if you do not have an employee handbook, email me today, right after this webinar. You'll have my email address. I can provide you with a sample employee manual that we give out to practices who don't have them. As an MGMA member, you're in, we have agreed with MGMA. We'll provide you with an employee manual. It's free of charge. Feel free to contact me, and I will send you an employee manual. If you want the sample employee manual just to compare to what you have, so you can cross-reference it with yours to make sure you didn't leave anything out. If you want to see how we worded certain sections, again, just contact me, and I'll make sure to get that to you as soon as I can. I may be referencing other types of personnel policies and procedures during this presentation. Most of those, we have them here as samples as well. For instance, a social media policy and securities policies for mobile phones and emails. Again, as MGMA members, you're entitled to this. We have that agreement with MGMA. Just contact me, and I'll make sure that you're provided with a copy of these policies. Free of charge. Again, this is something we want to do to make your life easier. Okay? So, employee manuals. Do you have one? You should. Again, Russian roulette if you do not have one. Do you follow what it says? That's another big red flag. When we have clients come in who unfortunately have a good employee handbook, but they're not following it because they don't know what it says, or they know what it says, but they don't really follow it. Those are two areas that we're going to try to address today. And finally, do you follow what the law says? It's important. Again, I don't want to overstate this, but I also want to be clear that it's important that every practice has a well-drafted employee manual, because you need to clearly articulate the set of rules and guidelines that are going to address everyday issues that come up in the practice, as well as those rare but significant occurrences. It could be such as like harassment or something else like the firing of an employee, something that hopefully doesn't happen often at your practice. Now, a comprehensive employee manual obviously should clearly explain your practice's policies as well as the consequences for violating these policies. It's important that every employee receive the same information about the rules of your workplace, because it's also important that every employee follows the same rules. You can't play favorites. This is an area where we've seen some practices fall into the very, very dangerous practice of allowing certain individuals additional benefits because, let's say, they work in a more profitable position. You know, well, I do all the scheduling for the surgeon makes the most money, and you know, he allows me to have a 90-minute lunch. Well, you know, that's not fair to the person doing billing in the back or the office manager who's, you know, running the practice. You know, you can't play favorites. That's the #1 area where we see a lot of practices getting in trouble, where a former employee brings about a lawsuit because you have practices in place, you have policies in place, but they're not being applied equally to everyone at the practice. You know, if you have an hour for lunchtime, that means everyone gets an hour. So, what should be in your employee handbook? As you can see from this list, which is not exhaustive, pretty much everything. You want the employee handbook to help you deal with the day-to-day issues. You want something that'll help you, you know, administrate and help you control what happens on a day-to-day basis. Now, can you have an employee handbook that's going to prohibit or in some way completely isolate you from any lawsuits? No, absolutely not. Just like a restraining order, no matter how strongly worded, can't assure that that person is going to be protected and that the person that they got the restraining order against isn't going to show up at their house. At the end of the day, a piece of paper is a piece of paper. But what it says can really protect you a lot. And if you don't have that piece of paper, then you don't have much recourse when you go to court. And we'll talk about a couple of cases, you know, as we progress through the webinar, where there are certain times that had the practice followed certain policies and procedures, they would have saved themselves quite a bit of money. So what should be in a handbook? All of these things. But what are the major policies that should be in a handbook? Well, that should be, first and foremost, employment at will. If there's nothing else that you take away from this, take away this much. In New Jersey, every employee is an employee at will, unless you have a contract that says that person is a permanent employee or that that person is somehow you know, contractually hired for a certain amount of years. I'm going to go back one slide just to highlight one thing for you. The 5th point down, probationary period. What should be in a handbook? Probationary period. We have had some instances where practices have come to us because they've gotten in trouble because instead of saying probationary period, they said something like temporary employment. Or they had a probationary period clause where they said that after 30, 60, 90 days, whatever the policy was, the person becomes a permanent employee. That is the worst thing you could possibly put in there. You're now converting an at-will employee, which you can fire for any reason at any time, and you don't need any rationale for it. Now you're making them a full-time permanent employee. You have to make sure that your employee manual specifically states that the employment is at the will of the employer and the employee. Employee can leave, employer can terminate. Works both ways. But it has to be clear, because if for some reason you leave that wiggle room, you put in something about temporary employment or probationary employment to permanent employment, that can wreak havoc on you. Compliance with federal and state laws, obviously, you know, everything from, you know, the FMLA to, you know, other state laws, you know, you got to have that obviously in your employee manuals. Your employees need to know what rights they have available to them, and obviously you want to protect yourself by saying, if God forbid you get into a lawsuit, the employee was apprised of all his rights. Non-discrimination, policy against harassment, immigration law compliance, these are also very important things to highlight in your employee manual. Procedures, Well, I'm not going to talk to you guys about procedures in the sense of the workflow procedures. You know, if you're managing a practice, you understand that, you know, you need, you know, people to do certain tasks. You know, some people are going to be, you know, in charge of administrative, billing, scheduling. Workflow procedures should be outlined where relevant in the employee manual. The best place or the best way that you can do that, in my opinion, is you just say, you know, for receptionists, you know, this is what your workflow procedures are. This is what is expected of you. You know, make sure that employees understand what is expected of them. You're also going to have, and this is where I'll come in a little more, compliance procedures. From a compliance procedure standpoint, HIPAA is obviously, you know, the elephant in the room. HIPAA compliance is something that needs to be addressed. Not just, hey, don't, you know, just talk to anybody on the phone, but what are your procedures? You know, if you're in a particular practice, let's say we see this a lot in pediatrics. Parents are going through a divorce. One parent comes in asking for medical records from the child. You understand, or you know, that they're going through a divorce right now. It's contentious, and unfortunately, the child, you know, they're bringing the child into the divorce. Can you give the medical records to one of the parents without both of the parents express, you know, written consent? There are, you know, a HIPAA analysis, like a big workflow sheet. You know, it's no, but if this, then yes, but if this, then no, but if this, then yes. You know, it's a whole complicated breakdown and analysis. To make your job easier, it's better to be overly cautious, you know, than try to make someone's life a little easier and expose yourself to HIPAA. So try to have procedures in place that you can rely upon when you say to a parent, listen, our office policy is with a minor child to have both parents, you know, request. That's not something that's, you know, burdensome, you know, unduly burdensome. I think it's something that's very reasonable to have, and, you know, in a non-contentious situation, you may not need to use it, but it's really something that you should have there that you should be able to fall back upon. HIPAA also applies to text messages, photos, emails. You know, as your patients become more tech savvy, they want quicker answers. They want, you know, not to wait. If possible, they want to do telemedicine, and they don't want to come into your office. So what do? They start emailing you pictures of a wart. They start texting you pictures. They start texting you, you know, their medical history and their current complaints. You got to make sure that you have compliance protocols, what you can and can't exchange via email, via text with your patients. Also, make sure that if you are sharing any information with your patients, any HIPAA-protected PHI, that you do so through encrypted emails. You can share information with your patients via email. You can also do it via text, but there are certain applications that you can use to send that information, and there are certain email protocols that you can use to send something encrypted, so that obviously you can communicate with your patient without worrying about violating HIPAA. As far as fraud and abuse, you know, that really, you know, is something that you really can't regulate too much. If it's going to happen, it's going to happen. So I'm not going to spend too much time at all talking about, you know, fraud and abuse in the sense of, you know, personnel policies and procedures. You know, sure, the policy and procedure should be not to fraudulently bill, not to, you know, bill for, you know, visits that didn't happen. But, you know, where applicable, you'll see it later in my presentation. Also, you should also have a grievance procedure. You know, what happens when someone complains about a coworker or a supervisor, one of the physicians? You should have some kind of procedure in place on how you can both insulate the practice from lawsuits in the future, saying someone was discriminated against, but also providing the employee some administrative relief, allowing them an opportunity to be heard, and allowing the person that's being complained about, because that's also important, due process to respond to any allegations. So, employee manual, salary, benefits, and policies. Obviously, one of the first things that people look at when they get hired, it's not, the HIPAA compliance policy, it's not the email and texting policy, it's, how much am I going to get paid? Do I get overtime? What's my vacation and holidays, sick leave, family leave? That's what a lot of people really care about when they get hired, and you must have that in there. You should have it, and again, it should be very clear, nothing nebulous or nothing nebulous or nothing confusing. One thing to note is we've had a lot of questions in the past at some roundtables and whatnot asking us, well, can we ask them to not discuss their salaries? And the answer, unfortunately, is no. There's no way that you can enforce it, and there's no, legal recourse that you have. Unfortunately, you can put a policy in place saying that, everyone's salary and benefits are, confidential and you shouldn't discuss them. But if push comes to shove, there really isn't much you can do in that light. So we'll get to the nurse who was awarded $15 million in a sexual harassment lawsuit. So how did that happen? Okay, well, let's talk about how this could have been first avoided. How do you discipline an employee? Well, first of all, you don't wait too long to impose a minor discipline. If you have an employee who's having performance problems, violating any of the policies or unwritten practices or methods of operation of the practice, maybe they're failing to comply with compliance plans, or they're abusing their privileges, like taking too much lunchtime. You have to write them up immediately. Don't wait for it. Don't, because once something else happens, you can't go back and say, well, you also did these things that I just never wrote down or never disciplined you for. Identify and specify the nature of the violation, document it, get your witnesses that can support the violation and the justification for the discipline. Check the employee's history of disciplinary actions. Check their performance reviews, any salary and promotional work history. I mean, you want to really try to make an educated, decision here as to what type of discipline you should hand down. Check that the discipline is being imposed consistently and fairly in comparison to other employees. That's also very important. You have to be consistent. If there's one thing that you're going to take away from this webinar is you have to be consistent. Once favoritism is established, you really run a risk of then leaving it up to the plaintiff's attorney to say why you were playing favorites. Provide the employee with an opportunity to respond. That can be either orally or in writing, and give your rationale if you reject their response. If you don't believe it. You got to advise then the employee of how his or her behavior has to be modified in the future, and do follow-up checks to make sure that that's actually happening. You integrate the discipline with the evaluation process, and you document the entire disciplinary process. So this is a step-by-step way of handling this. I skimmed through the Taking Steps to Protect Against Employee Lawsuits handout that we have. If you want a copy of that, I can send you that as well. That has very good information on how you can avoid employee lawsuits. Again, it's not ironclad. It's not going to prevent you, unfortunately, from frivolous lawsuits. Anyone can file a lawsuit. All you need is a couple $100 and a lawyer who's willing to do it, and the rest is up to the court. But if you want that document, I can certainly give it to you. So what didn't this one practice do? Well, the doctor was sexually harassing this nurse for years. That's your first indication of a huge problem. This should have been, if it happened once, should have been documented. The doctor should have been disciplined right away, told to stop, There should have been a follow-up, and the doctor should have, never been allowed to really have access to this nurse like this. Well, what happened? That didn't happen. They just brushed it under the rug. So what started with propositioning and groping unfortunately culminated in, 2 violent attacks down the line. So during the discovery, because the lawsuit was filed, obviously, that's how you get awarded $50 million, there were complaints to supervisors. And what happened? They were unresolved. You have to make sure that you make it known that all employees are responsible for ensuring a harassment and discrimination-free workplace, okay? This is, everyone's involved. Everybody's got skin in the game. You want to make sure that you specify the conduct and you specify, the reporting procedure. You want to make sure that, everyone feels comfortable that they can report it in a safe environment. There's not going to be any retaliation, and, it's an uncomfortable issue, but you really have to make sure that, you nip it at the bud and that you respond, swiftly to it. So personal conduct policies, there are a number of personal conduct policies. What I'd like to actually bring your attention to is use of computers. Obviously, with EMR, everyone had their computers all over practices now. And your employees need to understand that there is absolutely zero personal privacy. Even if they're using their personal email on your work computer, the practice owns the servers. The practice owns the information. You have no personal privacy. Someone could be logged on, looking at your screen, like they're doing, like everyone's doing right now to my GoToWebinar screen. That can happen at any moment in time. They have to understand that there's no personal privacy. And that's something that is basically the case everywhere. It doesn't matter, not just medical practice, law practices. We have the same kind of policy here. If you work in a corporate environment, it's the same thing. Another thing I'd like to call your attention to is billing. We work a lot with billers, and some issues that it's not prevalent, but some issues that we've seen come up is when a practice gets audited and they realize that they've been doing something wrong for a long time. They've been billing the wrong code, they've been using a modifier incorrectly, they've been unbundling something that used to be okay before, but now it's become part of a bundled code. If you have an internal biller, you should definitely have in place some sort of policy in place that allows for them to go out to get recertified, that allows them to continue with their education, to attend seminars, because the problem that you will run into if you don't allow your billers and your coders to go out and actually, learn about all the developments is that you're going to end up using outdated codes, and that's going to end up wreaking havoc on your bottom line, because eventually, all of the insurance companies are going to catch up, and it's going to end up in some nightmare stories like some that I heard at a recent coders convention day, where they were talking about a practice that was using the wrong code for a few years because the practice thought it was too expensive to send their billers out. So they didn't want to send all their billers out, to get, re-credentialed and to go to all these seminars because they just couldn't afford it. Well, they ended up with a $3 million overpayment demand and a corporate integrity agreement because they were, accused of fraudulently submitting claims for submitting outdated codes for a number of years. So that's your worst case scenario. So make sure that you definitely allow for your billers to be able to go out and get the education and the continuing education that they need. Doctors' offices, a lot of times you hear whistleblower lawsuits. It's against this hospital or that hospital, or it happens to small offices as well. There's a family practice group accused of employing an unlicensed personnel. So the former medical assistant, filed a whistleblower lawsuit which was then joined by the government, and ended up in unfortunately a large fine against the practice. If you're a small practice, a large whistleblower suit, it can destroy the practice. The other thing you need to take into consideration is that when you have a whistleblower lawsuit, the OIG, the Office of Inspector General, they actually conduct parallel civil and criminal investigations. And the civil and criminal departments, they talk to each other a lot. They share information. So there's always that possibility that this maybe coding error or hiring people who are not licensed to do the job or do the procedure that they're doing, while this may start off as a potential civil penalty, it may end up in criminal charges and an indictment. So whistleblowers, there are procedures for employees to report their concerns. That's not really the topic of this presentation, but there are certain things that they have to do. They have to report all issues that they discover, not just the ones that they think are juicy and that can get them paid. And the reason why whistleblower suits, by the way, the reason why they are so popular is because much like RAC auditors get a percentage of the audit overpayment demand that they obtain, whistleblowers get a percentage of what the government recovers. And it's usually about a third, so 33%. So we can talk about another way that a lack of policies cost a doctor's office. There was a case where a doctor's office manager was charged with forgery, theft, and unauthorized credit card use. This manager racked up $65,000 to $70,000, of personal charges. All of these purchases were unapproved, and there were checks written for larger amounts than the manager was authorized to write. So why did that happen? Well, this manager was able to take small funds over a long period of time. There were no policies in place to prevent single point of contact for finances. So there was no safeguards. There was no one there was to double check what the manager was doing. You really need to have in your policies and procedures, clearly outlined who handles copays, who handles petty cash, who handles the supplies. You should have some system of double checkings to make sure that when money comes in, more than just one person knows, more than just one person's holding the money. One person's holding the money, the other person's double checking it. You need to have a check and balance to make sure that no one is tempted, or worst case scenario, someone with nefarious purposes has an easy way to siphon out money. Another reason that you need to have office policies is unpaid overtime. There was a lawsuit about a particular practice. They had their assistant office manager and sales representative routinely work more than 40 hours. So they were entitled under the law, based on the size of the practice and other factors, to overtime. So what happened? Well, prior to the trial, it was settled for $5,000 of back wages. Okay, that's not a lot. But it was also settled for $30,000 of attorney's fees. So why did that happen? Well, employment law is different from civil litigation. In civil litigation, attorneys get a percentage. They might get a third of what they recover. In employment actions, there are provisions in the law, in the statutes, that allow for attorney fees. So the attorney fee provisions is what really racks up the value of these claims. And a $5,000 claim all of a sudden becomes a $35,000 settlement because the attorney's getting paid, 6 times what the the plaintiffs are getting. That's the reason why you want to try to avoid these employment lawsuits at all costs, because it's not just the fact that you may have some exposure, but even if you settle for a de minimis amount, you're still paying potentially a lot of attorney fees. So employee compensation policies, obviously you want to break down the employees by classification and part-time, full-time, probationary period. You want to have evaluations. On evaluations, it's often, from our understanding and based on our years of practice, it's often that performance evaluations are the singular most important documents supporting or justifying a practice's actions towards an employee. So employee performance evaluations must be prepared with care, and the practice's action towards the employee, be it a salary increase, a bonus, or discipline, must be consistent with the evaluation. So, while you want to be able to support a discipline, you also want to be able to support a bonus, because again, you don't want to have that situation where they're thinking that you have preferential treatment for some of your employees, because preferential treatment for one employee can be misconstrued as discrimination against another group. So we have a checklist of how you can prepare good end of year probation period and regular year-end probation evaluations. As part of our taking steps to protect you against employee lawsuits, handout. If you want a copy of that, again, just feel free to contact me, and I'll make sure to get you a copy of that, as soon as I can. Wage and hour rules. Again, you have state and state and federal rules concerning wage and hours. Sometimes these rules work hand in hand, they overlap. Other times they conflict. They govern everything from how much someone can get paid to overtime, leave, discrimination, workers' comp, everything. And again, definitely want to call your attention to the fact that most of these provisions, regulations have provisions for paying counsel fees. So it's very important that you know what the rules are, what the regulations are, because the worst thing you can do is run afoul of them and end up paying a ton just in legal fees for the plaintiff. Most of the lawsuits that I've handled here, the litigation department of the firm deals with the Americans with Disabilities Act. As employees, you have to provide reasonable accommodations, and they have to be reasonable. That's something that gives you a little bit of that wiggle room. So if you ever have a question as to whether something is reasonable or not, call healthcare counsel, call employment counsel, either one. But make sure that you run it by them to make sure that you're not doing more than you have to do, because you still have to be reasonable. As far as impaired employees, you have to report issues, and there's an intervention process. All of these things are outlined in the Americans with Disabilities Act. And you also have, under the American with Disabilities Act, you should understand patient-based reasonable accommodations, and we'll get to that right now. Or maybe not right now, but in a little bit. So there was, an employee who was fired for posting on Facebook. So we'll take a quick shift to social media, and you should have social media policies as well as part of your employee guidelines. So an employee was fired for posting disparaging comments about a supervisor on Facebook. The National Relations Board, Labor Relations Board, filed a complaint alleging that the employer was prohibiting a concerted protected activity, obviously. Well, the case was settled, but again, they had to agree to change their policy because they didn't have very good policies about, what you can and can't post online, what you can and can't post on Facebook, what you can and cannot post about the practice. You really need to have a good social media policy, especially now that social media is everywhere. Twitter, Facebook, Tumblr, Instagram, whatever you want to use, it's really important that you're up to date with all of that. Hostile work environment, social networking, it can be great, but it can also be used to create a hostile work environment. You really need to have a policy on social networking. Let your employees know exactly what they are permitted to do, what acts are considered prohibited. Again, we have a social media policy that we can certainly share with you if you need that. A good rule of thumb is to permit and prohibit those acts online, just like you would, in real life. There are some cases that, were recently in the news. In one of them, you have 5 nurses who were fired for discussing a patient on Facebook, even though there were no names, photographs, or other identifiers included. And 3 years ago, that same hospital fired 10 employees for taking cell phone pictures in the ER. So even when you think that no one's looking, or no one's ever going to watching, or no one's going to be able to identify, what you're talking about, you're still running a risk of, HIPAA violations, getting terminated. Then the board gets involved, and that can be a huge nightmare. If you're trying to explain to the board why you're disseminating on social media protected health information. There was another case that's even more incredulous than the 5 nurses who discussed patients on Facebook. There was a physician who had a blog where he would complain about patients, he would complain about nurses at the hospital, and the physician actually was posting under an alias and was actually posting that he was in a completely different state. So there was nothing that the physician thought tied the website, the blogs, back to the physician. Well, it so happens that someone did find out. There was one particular post that somebody had rung a bell. It's like, well, that's something that happened at this hospital, and I think it may be this person. And it ended up with that person being disciplined by the board, and the website was taken down. It's better to just stay away from all of that. There's absolutely no need for that. You should really have a good policy in place to make sure that nothing is discussed by any employee about the patients. Patient confidentiality, obviously, there's implications for HIPAA, tort law, and even criminal activity. You have to have a good confidentiality policy that should cover social networking and mobile devices, because a lot of this trouble now is stemming from inappropriate use of, smartphones, taking pictures and loading them up to Facebook, Tumblr, Instagram, wherever. Before I wrap up, I just want to talk about a couple other quick provisions. An arbitration clause. We like to, we advocate to use a mandatory arbitration clause so that all legal claims or disputes that arise or relate to employment are exclusively submitted to final binding arbitration. Okay? You want to get this out of the court. They waive their right to pursue their claims in court. This, though, needs to be disclosed in advance, because if you sneak it in there, like a lot of nursing homes, for instance, were found guilty of doing, it's considered to be invalid. So have a completely separate piece of paper and have them sign that. Have them make sure that they agree to a mandatory arbitration, because it'll save you time, it'll save you money, and it'll be a lot quicker. It's definitely something that is far better than a public lawsuit. Communications. This comes from a recent roundtable that we did. You really need to make sure that you have good policies on communications, because medicine is a service business, and what makes a business successful? Well, that's satisfied customers. So you want to really stress that all your staff are competent, friendly, and responsive when communicating with patients. You want to have a pleasant surrounding. There was a neurologist who failed to provide effective communication. This was in the news not too long ago. The practice basically refused to pay a sign language interpreter for a deaf patient. Again, American with Disabilities Act applies not just to how you treat your employees, but also how you treat your patients. So he was required to implement proper policies, post notices, train all of his employees, and pay, although small amount of damages and penalties, quite a bit of legal fees. So you really want to be able to make sure that you're always compliant with the American with Disabilities Act. As I mentioned earlier, it applies to patients just as much as it applies to your employees. Some miscellaneous policies, admission of visitors, physician absence, supplies, lunch hour, coffee and lunch rooms, dress code. I want to definitely just spend a couple of seconds on letters of recommendation. A letter of recommendation, you should definitely have a policy noting when that is given and when that is not given. A problem that we see sometimes is a practice has an employee for a number of years. There's a break in the employment and the employee is terminated. There may or may not be a lawsuit and a settlement, and then that employee who has worked primarily for that one practice is now looking for other jobs. What do other jobs want? Letters of recommendation. So they ask for a letter of recommendation from, the prior employee. Well, the employer, so, what's the employer going to say? That this person sued me and they're malcontent? Well, that's just inviting another lawsuit. So sometimes it's good to have a policy that says that when requesting a recommendation, the practice will provide the dates of employment, the title, and will advise the requesting party, potential employer, that office policy dictates that no further information be provided about the former employee. You can have something that, although it doesn't sound very nice, you can have something that's very straightforward like that so that no one asks you for letter of recommendations. Now, if you happen to have an employee who leaves, you don't mind giving a good recommendation for, and you want to violate your own employee manual to give that employee a good recommendation, by all means. No one's going to bring you to court for helping them get a job. But the opposite of that is true. If you have a policy that says we will provide you with a gleaming letter of recommendation if you ever leave our practice, and now the person who you had to fire because they were embezzling and then sued you for discrimination now is asking for your letter of recommendation, and you deny them, and they then point to your employee manual, then you have another trial in your hands. There are a number of applicable laws. You will get this PowerPoint presentation from Dawn, and I just want to call your attention to the fact that they really do regulate every aspect of the practice of medicine, your day-to-day practice, and it can be big ticket items like workers' protection, like OSHA, to Family Leave Act, how much you pay somebody, Whistleblower Acts, False Claims Act, preventing discrimination, and then obviously the big one is HIPAA. So, take a look at some of these. If you have any questions about them, you can always contact me. I'll be more than happy to help you in any way that I can. And then, one of the last things that, I want to point out is the fact that, quality does equal perception these days. With Yelp and, Rate My Doctors and all these other, Vitals and all these other websites that rate doctors, quality, and your ratings are very important. Most patients, they really, can assess the quality of the attention they receive, but they can't assess the care, the quality of care they receive. So a good bedside manner is really considered, good care. And the bedside manner does begin with the first impression, which is a lot of times the receptionist. Studies have proven that, the single most important element in the customer patient satisfaction is the first impression. So the appearance of your office, greeting at reception, making patients comfortable, explaining delays, all of these things, help you become a better rated practice. And all of these things can be addressed in your policies and procedures by making sure that, the staff knows to make sure that the office is kept, not in disarray, make sure that the, welcoming area is kept in a nice, orderly fashion, that the receptionist knows how to greet the patients, and knows how to keep the patients comfortable and explains delays in a reasonable and compassionate manner. That also includes answering the telephone. It can be as simple as having someone respond to your telephone. You have all this material. You can read through some of the findings from a study that we've put into this PowerPoint presentation. And if I'm going to leave you with this now, it's build an employee handbook that's custom fit to your practice, enforce the handbook equally amongst everybody, and update their handbook frequently. What we say is pick a day of the year. It could be tax day, April 15th. It could be, June 30th. Pick a day. Every year, that day, update your handbook, based on what happened in the practice during the last year, based on any updates in the law, whatever happened. So make sure to update your handbook frequently, every year if possible. We've had some roundtables in the past, and some practice managers telling me, oh, well, our employee handbook is the same as it's been since 1999. Well, the law's changed quite a bit. You have medical records. Now you have so many updates to HIPAA. There's so much that has changed. Don't let it go more than a year. If you have questions about how you should update it, or you want someone to help you update it, you can always contact us. And with that, I thank you for your time, and I'll leave this open to any questions. If you don't have any questions now, or if you want to look through the materials and then email me a question, you have my contact number there, and you have also my email. Thank you very much.
Thank you so much, Guillermo. It looks like we don't have any questions at this point. I'll give a couple seconds here just to wait to see if one comes in. If not, everyone, you do have Guillermo's contact information. You can send questions his way. I'm getting a couple questions about a sample for the handbook, so I'll get that information to you. Any other requests for the handbook, if you can send them directly to Guillermo, that would be great. But Frank, who requested it, Frank, I'll get your information over to Guillermo so he can send that out to you.
Perfect. Hey, yeah, I'll do that.
Doesn't look like we have any other questions, so thank you very much, and everyone will be receiving the presentation shortly. Have a great day, everyone.
Have a great day. Thank you.